Please be seated. Well, good morning. Thank you all for coming today. As you already know, this is the time set for an oral argument in 190077, known as this Watchtower Bible and Tract Society et al. For those of you who are not familiar with the members of the court, I guess even for those who are, I'll introduce each of the members. On my far right is the Honorable Dirk Sandifer, Justice Beth Baker, Justice Ingrid Gersh, on the far left is Justice Jim Rice, Justice Jim Shea, Justice Laurie McKinnon, and I'm Mike Graff, Chief Justice. With that, I'd like to read.
May it please the court, good morning. My name is Brad Luck, Garlic and Lyon Robinson in Missoula, appearing on behalf of the appellants. I'd like to introduce the court to Joel Taylor, who is Pro Hoc counsel, who also is one of the trial counsel in this case. Mr. Taylor is going to argue the case today.
Thank you, Mr. Luck. Mr. Taylor?
Mr. Chief Justice, may it please the court. My name is Joel Taylor, and I represent the appellants Thompson Falls Congregation, Watchtower Bible and Tract Society of New York, and Christian Congregation of Jehovah's Witnesses. I would like to reserve 10 minutes of my time for rebuttal. This appeal involves religious folks in Thompson Falls trying to do the right thing. In 2004, elders learned of abuse that had occurred years earlier in what they believed to be confidential circumstances. Immediately thereafter, they sought out legal advice on their reporting obligations by contacting an attorney with Watchtower of New York. Then, following in established church practices, the local congregation conducted an ecclesiastical review of the wrongdoer's sin and repentance, and thereafter removed him from the congregation. That review also included contacting an elder with Christian Congregation of Jehovah's Witnesses in New York. At the time of the district court's August 30th, 2018 order, these facts were not in dispute. However, in just 4 sentences, the district court determined that Montana's reporting statute applied, but its confidentiality exception did not. And the court did not say why. The district court decided causation and didn't say why. The district court determined agency relationships among the appellants and didn't say why. Nothing in the record at the close of discovery supported the order. Plaintiff even argued that material issues of fact prevented granting the defendant's motion for summary judgment on the negligence per se claim. Despite evidence and admissions to the contrary, the order painted appellants as lawbreakers who were callous toward child abuse. Nothing could be further from the truth. All Christians, all people, abhor child abuse, and our sympathies lie with the victim in this case. However, that order laid the basis upon which this shocking $35 million judgment sits. Because of these errors, we ask this court for a reversal. To be clear, this case is not about general negligence. On day 1 of the trial, the plaintiff strategically dismissed all of her general negligence claims because she knew she couldn't meet her burden to carry common law duty, breach, or negligence. Nor is this appeal about jury instructions. It's about the August 30th order and the facts in the record at that time and the jury's subsequent verdict of compensatory and punitive damages. To begin, the most glaring error has to do with the issue of causation. In the district court's order, the judge took the critical issue of causation away from the jury. This court, in Stipe versus First Interstate Bank, made clear that even on a negligence per se claim, per se negligence only establishes duty and breach. causation and damages remain for the jury. The district...
Can we consider, as the plaintiffs contend, the weight of the evidence on causation to hold that the district courts, or to consider whether the district court's summary judgment ruling was harmless?
Excellent question, Justice Baker. Well, let's talk about the evidence that existed at the time of the district court's order. Plaintiffs had no causation expert, and the only evidence of causation really worked against the defendant, or plaintiffs. And that is that Mr. Reyes, the accuser in this case, was reported twice to the authorities. And the plaintiffs acknowledged that even after both reports, nothing happened. And so what causation addresses then is not whether or not harm flows from abuse, but the question is whether or not harm flowed from the failure to report. And would the failure to report have prevented further abuse? And that question was not presented to the jury.
Excuse me, there's no requirement, as you're aware, to have expert testimony to establish causation, particularly in a fact-driven situation like this. And so with that in mind, why is it not within the purview of the jury to decide the sufficiency of the evidence as it relates to causation?
Justice Sandiford, I agree with you 100%. It is within the purview of the jury. That is consistent with the precedent that this court has issued in state.
But let me stop you. And I understand your point, but this goes back to Justice Baker's question when she's asking you in regard to harmless error, whether or not or to what extent it's proper for this court to consider the state of the evidentiary record at trial. So are you asserting that there is insufficient evidence in the trial record to support a causation finding?
There is insufficient evidence in the record that existed at the time the judge issued his order to support any finding of causation. Unfortunately, we can't put the cart before the horse. So the judgment does not precede the proofs. The proofs must precede the judgment.
But that wasn't her question. Her question was in regard to a harmless error perspective on this. What was the state of the evidence at the trial? And how should we view that?
Excellent, Your Honor. There was no evidence on causation at the trial because the judge had already summarily decided the issue of causation. So there was no further, up to the point of the hearing, there was no evidence. Trial adduced no further evidence because the judge had already decided the issue and took that critical issue away from the jury.
So when the jury verdict form says the negligence of those named below caused injury to the plaintiff, they answered in the affirmative. And so you're saying they didn't base that on any evidence presented at trial?
Actually, one jury instruction involved a plaintiff who was dismissed, but the answer to the question about negligence per se as to Alexis was determined by the court. And that answer, yes, was not inserted by the jury. It was already in the jury instructions. The jury did not opine on causation at all.
Counsel, you said that causation is the primary consideration in this case, but we don't even get to causation until we find the statute, the reporting statute is applicable here, because that's the basis, the statutory basis. So can you address the statute and the exceptions to the requirement for reporting?
Indeed.
And am I missing something? Don't we have to get there before we get to causation?
You're not missing anything, okay, Justice McKinnon. It's just that causation was the most obvious one to see. But we can discuss confidentiality. And the exception to confidentiality is found in subsection 4C of the reporting statute. And we provided a copy of the reporting statute. It's page 10 of the handout in front of you. But the reporting statute says this, as it relates to confidential communications under 4C. A member of the clergy or a priest is not required to make a report under this section if the communication is required to be confidential by canon law, church doctrine, or established church practice. Even plaintiff agreed that the way the elders handled it was consistent with the practices of the faith of Jehovah's Witnesses. But the order gave no indication of any meaning on the part of the judge about Jehovah's Witnesses' right to this exception. In fact, it trampled upon the deeply held, constitutionally and statutorily protected religious beliefs of Jehovah's Witnesses.
Let me ask about that before you go further. What evidence did you offer in support of the exception about the canon law, church doctrine, or established church practice?
At the time of the August 30th order, what was in the record were admissions from plaintiff's mother, plaintiff's grandmother, plaintiff's uncle, 2 elders in the Thompson Falls congregation, a former elder, the corporate representative of the 2 New York corporations, all of whom agreed that the way this matter was handled was consistent with the established church practices of Jehovah's Witnesses.
So can you address the counter argument, which is that by revealing that information to so many parties, that it lost its confidentiality?
Indeed. Plaintiff argues that confidentiality can only have one meaning, in that it means that it's between one person and another. And the statute does provide for that type of confidentiality in exception or subsection 4B. But 4C is a different subsection, and it adds different meaning to the word confidentiality. In fact, it's more consistent with what the legislature has said in connection with its use of confidentiality. In at least 5 different areas in the Montana statute, the word confidential is used. And in those usages, it allows for disclosure of information while maintaining its confidential status.
What about when the person who's making the report, because as I understand it, Peter didn't expect it to be made confidential, and there's a reference in the brief somewhere that he said he wanted it out there. And so if he's the one making the report, and he says he doesn't want it to be confidential, it seems to me that the victim making a report who does not desire it to be confidential pretty much holds the card there.
Well, Justice Shea, that's an excellent question, but it mischaracterizes ever so slightly the evidence. At the time of the August 30th hearing, Peter said that he wanted it out. And then when asked about those questions further, he said that he wanted the elders to know. And then it was a follow-up question. Peter, was it handled exactly as you wanted it to be handled? And his answer was yes. He said that at deposition, it was in the record at the time of the August 30th hearing, and he also reiterated it at trial. During the deposition, Peter stood on his own privilege and refused to disclose what he told the elders in confidence.
And Mr. Taylor, is Peter's consent, I'm looking at the difference between subsection B and subsection C of the statute, and it seems like the consent of the person who makes the statement is most relevant under subsection B. You haven't argued confidentiality under subsection B, have you?
We have not, and you are correct.
But since B and C are part of the same statutory structure, how would we opine that B, confidentiality, means one thing, C, confidentiality, means something different?
Well, the legislature, in protecting both the one-on-one model, which is found in B, and then also allowing each faith to determine its practice in addressing sin and repentance, essentially it rejected a one-size-fits-all approach that would have discriminated against some faiths while favoring others, in violation of the First Amendment and also Section 2, Article 5 of the Montana Constitution. So in deferring to the faiths, the legislature then remained well within the confidential bounds of not establishing a form of religion or inhibiting one's free exercise of their faith. And so, as it relates to confidentiality alone, if the exception applies, then this case should be remanded with instructions for the verdict to be vacated. Another issue that warrants some discussion is the issue of agency. Before this appeal, the plaintiff strenuously argued that each defendant had an agent who violated the statute. Watchtower had an attorney who violated the statute. Christian Congregation of Jehovah's Witnesses had an elder who violated the statute. And the Thompson Falls congregation had an elder in Montana who violated the statute. In fact, at the hearing on the argument for this motion, plaintiff's counsel said this. So, for example, Your Honor, The elders, the local elders at Thompson Falls, are clergymen that knew about the abuse. And we're using vicarious liability to make the local congregation liable. CCJW have clergymen in their service department who knew about this. And we're saying that CCJW is vicariously liable. So their argument was each entity had an agent who violated the statute. In fact, 1 year ago, in opposition to the defendant's petition for a writ of supervisory control, this is what plaintiffs argued to the court. The court found that defendants are vicariously liable for their agents' failure to report. It is undisputed that agents for each defendant received notice of the 2004 abuse and that these agents were all clergy as defined under Montana law. Each defendant has stipulated the agency of its actors. Based on that agency relationship, the corporate defendants are vicariously liable. So their argument to this court and to the trial court has been that each entity had its own agent. But there are problems with that argument. For example, as it relates to Watchtower, attorneys are not specifically listed as mandatory reporters in Montana statute. So even if Montana statute reaches into New York, attorneys are not mandatory reporters.
Well, it's pretty clear that the plaintiffs are arguing that the Thompson Falls elders were acting as agents of the parent organizations because their failure to make the disclosure it furthered the interests of the church and its policies. And so I don't think we're really talking about the lawyer or the people in New York as the agents that the plaintiffs are relying on. They're talking about the folks in Thompson Falls.
I would say, in response to that question, that is an argument that they're making today. That was not an argument that they were making or propositioning to the court when the district court entered its order on August 30th, 2018. But we can take it both ways. Clearly, if the Watchtower attorney is not a reporter, then any judgment as to Watchtower would go away. If Montana statute does not reach into New York to address the elder at CCJW's verdict would go away. And that's why, to your point, the transition has been made to the argument that, well, this one elder was the agent for all three. Well, there's a couple problems with that. One, there was no evidence of agency entered into evidence at any point prior to the August 30th hearing date, except that the elder was an agent of his local congregation. What is more, if we follow that theory, it undermines plaintiff's entire punitive damages claim. Because if the failure to report rests solely with the elder in Thompson Falls, and there's no finding of malice as to him, how could there be vicarious malice to the principals? It doesn't follow. And then the entire punitive damages phase of their case, it collapses. The elder only failed to report once. And if he is the agent for all three, and sometimes his conduct is malicious, and then other times is not. If they argue that, well, the Watchtower has policies, or Watchtower does this, or CCJW does that, that's a different case. That's not negligence per se. Those are common law negligence claims.
So, counsel, I'm just trying to envision a situation where you have the corporation or the organization based in Montana, members of that organization, you have communications made to the elders, who then talks to the organization, the elders in the organization. When are you saying that the organization never would be liable for failure to report? It's assuming that we had everything in Montana, and assuming we didn't have it disguised under attorney-client privilege. There has to be a way where an organization keeps quiet this kind of activity. Under what facts can that happen? I guess is what I'm trying to get at.
Justice McKinnon, I appreciate the concern. And I'm unclear under exactly what facts. But what I do know is that the statute says who is a mandatory reporter. And if any of those individuals listed, those officials and professionals listed, fail to report, then they are negligent per se, absent any exception.
So you have it, so what? So you have one person who's liable. that's not going to solve the problem when it's an institutional problem of cover-up, which is, I think, what the always are. How do we get to that problem?
Okay, well, two things. One, the legislature could adjust the law. But secondly, it does not absolve a plaintiff of asserting her common law negligence claims. It does not. Plaintiff still has the right to bring those claims that there was some conspiracy or other activity that resulted in harm to the plaintiff. But it's just not the vehicle to use the negligence per se statute. So I do think there is a remedy, and there ought to be a remedy, and it exists in the common law. The other issue perhaps we could just spend a few moments on has to do with extraterritorial application. And depending on which argument plaintiff uses toward this issue of agency, the question arises that if the statute reaches into New York, does that mean then that every professional or official, every teacher, social worker, police officer, minister who learns of abuse in Montana is a mandatory reporter in Montana wherever they live in the world? And such a sweeping interpretation of the law could have serious consequences. What is more, what happens if the reverse is true? If every Montana teacher, social worker, police officer, or minister, if they become aware of abuse in another jurisdiction, are they now a mandatory reporter in that jurisdiction? Any interpretation of the statute that includes vicarious liability would convene, or rather contravene, the common law duty of no duty to rescue, and would expand liability beyond the circle that the legislature drew. And what I found interesting is that in Montana statutes, Title I, Chapter 2, Section 101, says the role of the judiciary in part in the construction of a statute is to simply ascertain and declare what its terms are, not to insert what has been omitted or to omit what has been inserted. And of course, this court is well aware of that statute, but it begs the question then to plaintiff's argument that they insert things, vicarious liability, extraterritorial application, that don't exist in the plain language of the statute. One last area, if we could discuss, has to do with punitive damages. If the court gets beyond the issues of the confidentiality exception, extraterritorial and vicarious liability, and looks even beyond the absence of an opportunity to present causation to the jury, there was no clear and convincing evidence of malice to warrant a jury's finding of punitive damages. There was no evidence of intentional or reckless violation of the statute. The Montana elder, who may be the agent now for all three, he sought legal advice on his reporting obligations.
Counsel, was the advice of counsel pled as affirmative defense?
It was not. It was not. That issue has been raised, but not by the appellants.
So you're not relying on that?
No, we're not. We're not. The elder sought legal advice because he was trying to do the right thing. That's all he was trying to do. The Watchtower attorney that gave legal advice, there's no evidence of malice. In fact, he didn't even know that the plaintiff existed.
Was he was in New York, correct?
Correct.
Was he was giving advice on Montana law, though?
Correct.
Was he a member of the Montana bar?
That was never adduced at trial. Never adduced at trial or either before.
Mr. Taylor, one of the things you cited in your briefs is a document that was your own declaration submitted after the verdict in this case that attaches the 1998 request from the legal department to Montana Attorney General for an opinion about interpreting the statute and the Department of Public Health and Human Services' response to that. The plaintiffs argued in the district court that because none of this came to light until after the verdict, it shouldn't be considered. But you cited it in your briefs, and I guess I'd like to hear from you about under what authority we could or should consider it in the appeal.
Well, we think it goes to the issue of malice. And of course, at the time the judge has the opportunity to review the punitive damages award, he considers evidence. And we felt that that document, although it was not located in time for trial, was relevant. The reason why it wasn't located in time for trial, as my declaration explained, was because it was on a 20-year retention cycle. It came up due for destruction in 2018. after the trial had ended. And lo and behold, we look, and there it says from the Public Health and Human Services Department that a report is not mandated on an adult reporter. Well, that was one of the adults who came forward in 2004. What is more, it says that even if you learn of abuse from the victim, it still can be considered confidential under subsection 4C.
Peter was a minor at the time he reported that, correct?
He was 17 and 2 weeks away from his 18th birthday. He
Or
testified.
another was a minor.
Agreed. And he testified that the abuse had ended 4 years earlier, that the perpetrator was no longer in the family home, and that he was moving out of the family.
Well, one of the things, and this goes back, I think, to your negligence per se argument about whether they were in a class, whether Lexi was in a class of individuals designed to be protected. You cited the Gross case, and as we have even noted in the Gross case, that child sexual abuse is chronic behavior. Isn't part of the theory there is that she was still exposed to Max Reyes, and there was, the nature of it is, the nature of pedophiles is, it's a leopard doesn't change its spots. And so doesn't that you have this narrow interpretation of who are the people who are sought to be protected? Isn't it, you can't say all children, but certainly children who are being exposed to the individual. Isn't that fair?
I think that's an excellent question. And you are correct that we did brief the issue of whether or not the plaintiff was in the class of persons designed to be protected by the statute. The challenge you have there is with the site factors, one of them is that the plaintiff must be in that class. The statute plainly says that it's designed to protect the child about whom the report is made. And nothing in the statute says that it's designed to protect children other than the child about whom the report is made. And a survey of the 50 states has turned up 7 other states that have similar language to Montana. And all 7 states have limited negligence per se to only the child about whom the report should have been made. They did not extend it. Now, plaintiffs do cite one case, and it's an Arkansas case for the proposition that the child abuse reporting statute is designed to extend beyond that one child. That statute expressly says that it's designed to protect not only the child about whom the report is made, but also any other children under the care. And in that case, it involved a teacher who became aware that a fellow teacher had abused children. And that teacher was found negligent per se because the statute said you need to report not only the child about whom the report was made, at the time the child was an adult, but you must also be concerned about anyone who else is under their care. And because the perpetrator in that case was still teaching, she still had children under their care. So it was well within the class of persons designed by that statute. And what I would say to that point is that religious organizations, we are trying. And any guidance you give us, we will follow. We have no desire to see the horrible things that happened to Ms. Nunes happen to others. At the same time, we try to balance our deeply held religious beliefs with statutory language and a desire to do right by both. And unfortunately, not every time is there a good result. And this is one of those times. And that's why we feel that this issue of punitive damages is so strong to us, because there's no evidence that the Watchtower even knew of the existence of Alexis Nunes. And both Alexis' mother and grandmother, who were charged with her custody, independently knew about the step-grandfather's conduct. And what the Thompson Falls elder knew was never conveyed to anyone in New York. I'd like to reserve the rest of my time for rebuttal.
Yeah, that's fine. Let me just ask one quick question just to clarify. So your position is that failure report on the part of the Thompson Falls elder, Mr. Herberger, was negligence per se, but the plaintiffs did not prove causation or agency.
No, I'm saying that Mr. Herberger was accepted from reporting because of the exception found in subsection 4C.
All right, so your repeated references to failure report as negligence per se is just generic to somebody that's not a member.
Correct.
Jim Malloy for the plaintiff and appellee Alexis Nunez. With me today are co-counsel Ross Leonidakis, Ross Labrie, and Neil Smith. Two victims notified defendants in 2004 that Max Reyes, a fellow member of the Jehovah's Witnesses, repeatedly sexually abused them over a number of years when they were children. One of those victims was Peter, still a minor at the time. Defendants responded to that report by sharing the information from the victims with multiple other individuals, including the pedophile wife, officials at Watchtower, CCJW. And at the time this occurred, the defendants knew that a young child was attending church regularly in the Thompson Falls Church with Max and Joni Reyes. That child, 7 years old at the time, is our client, Lexi. Reyes was abusing Lexi at that time. He continued to abuse Lexi for the next 3 years after the defendants knew and had a confession from a pedophile who had repeatedly sexually abused children.
Mr. Malloy, putting aside for the moment the question of who is the mandatory reporter under the statute, are you asserting on the one hand that this report was made to the Thompson Falls clergy outside the framework or scope of the established religious practice and procedures of the church? Or are you alternatively, tacitly or otherwise conceding that it was, but nonetheless it wasn't confidential because this information was passed up the chain to New York? Or something else?
Justice Sanford, there are two parts to the answer to that question. We are asserting that under any plain meaning of the word confidentiality, this information was not kept confidential. And the church doesn't define what the law says. Courts define what the law means.
What aspect, I want you to continue with Justice Sanford's question, what aspect was not confidential?
Sharing information with multiple different people is not, under any plain meaning of the statute or the word confidential, keeping it confidential. I'd like to get to the second part of the answer. The focus here has been on they are ignoring a crucial element of the exception in 4C. If you look at the language, it says required to be kept confidential by church, by canon law, or established church practices. At CR 51 in the record, this court conducts de novo review. You will find deposition testimony from Douglas Chappell, corporate representative for CCJW and Watchtower, in which he testified under oath. It was information available to the judge as of August 30th. He testified under oath that an elder can report a child abuser to the authorities if they choose to do so. That's Exhibit C to CR 51. Dawn Herberger, the elder in Thompson Falls, testified to the same. An elder can choose to report a child abuser to the authorities. Therefore, this court really never even needs to get to the question of did they follow established church practices? If so, what is and is not confidential? They miss the fundamental element of that exception. It must be required to be kept confidential. And there are multiple places in the record before August 30th and at trial where they say we report if we're required. You can't have it both ways. You can't say we report, but it's required to be kept confidential. Their own witnesses acknowledge that it isn't required to be kept confidential if an elder chooses to report a known child sex abuser.
Let me ask you on another point then. Mr. Taylor says that the record suggests that on at least 2 occasions this was reported to authorities and they did nothing. Do you agreed with his analysis.
What I'd like to do is put that in context.
Please.
And in doing so, if I might address the causation argument, because Chief Justice is directly related to that. The short answer to your question is they elicited that testimony at trial. The testimony was remote in time, 2007 and 2015, to the Sheriff's Office. It was not to the Department of Public Health and Human Services. The Sanders County Sheriff's Department does not have a statutory responsibility to follow up in response to a report of a known child sex abuser. That authority, that responsibility, lies with the Department of Public Health and Human Services. And it is a mandatory. The statute 202 says the department shall, and as this court has recognized and it is well established, that the law presumes that a public official will perform their mandatory statutory responsibilities. To circle back, it's important to...
The key to that is public official, which we don't have here.
In this case, Justice Kidd, so we don't have a public official?
Well, I guess that gets back to the argument about the organization, and I'm sure you're going to address that as well.
Yes. You mean CCJW and Watchtower. I will get to that. So, the defendants did not report a known child abuser to the Department of Public Health and Human Services. That was not an accident. It was not an oversight. Pursuant to established policies, local elders are instructed to contact the national organizations when they learn about a child abuser. That is precisely what they did here. They were instructed not to report. And then Lexi continued to be abused. To address the issue of causation...
Well, isn't that a requirement that they not report according to their church law?
No.
If in fact they're instructed upon a report to contact the national office and receive instructions, and they do that, and the instructions are, don't report. So isn't that in the framework of the church doctrine?
It may be with respect to internal ecclesiastical practices, Justice Rice, but it can't be if it has to do with a known child abuser and a mandatory reporting law. What happened here, we don't know the conversation that occurred between the elder who didn't testify at trial and the people in New York. What we know is they were instructed not to report. We also know that the elders for Watchtower, CCJW, and Thompson Falls Congregation testified that they can report.
Do we really want, and I think, do we really want to be looking into what's going on within church circles? And doesn't that bring us right up against the First Amendment? And I think that's what Justice Rice's question is getting at, is if they aren't told not to report, I mean, we're going to be examining what's going on in church governance.
You don't need to, Justice. Okay. This court has recognized, and I may not get the quote precisely right, freedom of religion to exercise religion and religious belief is absolute. No one disputes that. But government has the right and the responsibility to regulate religious conduct for the protection of society. And there could be no more appropriate situation than the case pending before this court to apply that principle. And it's articulated by this court in the Davis versus Church of Jesus Christ of Latter-day Saints case. It's recognized by the United States Supreme Court. This court need not immerse itself in church doctrine, in church practice, to decide whether the clergy exception they rely on applied. It didn't apply. Their own admissions state that they could have reported a sex abuser to authorities. Now, the inconsistency here is that they say, well, but our church practices say we don't. If this court is going to sanction a religious institution defining for itself the outer bounds of what confidentiality is, then the reporting statute is eviscerated and is meaningless as it relates to victims of child abuse in the religious context. That's the simple result.
Mr. Malloy, just what you just said, that inconsistency, that evidentiary inconsistency, on the one hand you have the evidence that you point out that gave them the other the discretion to report this, presumably viewed in that fashion without contradicting or contravening religious canon or policy. On the other hand, as you point out, there's evidence then that it was policy not to do that. Does that not create a genuine issue of material fact that should have been decided by a jury and precluded summary judgment that was granted pre-trial?
Thank you, Justice Sandiford. If I might address, because I think you just asked the causation question. And first of all, the court's August 30th order, there are a few important things that were not pointed out to the court in opening argument. At the time the judge rendered his orders on August 30th, he had before him the final pretrial order that had been jointly prepared and submitted by the parties. So he had a number of stipulations, a number of contentions that he could also review. And this court gets to conduct a review of that decision. And you have before you at CR 77, CR 51, you have evidence that you can review. Now let's walk through it. First of all, it is not entirely accurate to say that he entirely took causation away from the jury. The terms of the order itself says that the plaintiff had the burden of proving the harm caused by Max Reyes.
But wasn't the causation on the verdict form filled in?
Yes, I'll get there.
What you just mentioned is the damages element of a negligence. So there's duty, breach, causation, and damages. And your brief doesn't seem to defend the court's ruling to take causation away from the jury. Is it defensible?
I believe it is, Justice Baker. Let me explain why. First of all, it didn't entirely eliminate cause, but the second point is very important. The defendants had three primary causation arguments they were relying on before trial. The first was harm caused by other abusers. The district court correctly rejected that defense and held it inapplicable. The defendants have not appealed that order. It's the law of the case. So that's one of their three causation arguments. The second was that the abuse by Max Reyes constituted an intervening and superseding cause. Again, the district court, based on Montana law, held that defense inapplicable, and they do not challenge that on appeal. The third, and this is very important, this was their third causation argument. Their third causation argument is that it was the acts and omissions and the negligence of Ivy McGowan Castleberry that was the primary cause of Lexi's harm. That issue remained in the case. It was fully litigated. At trial, defendants elicited testimony. They made arguments. They made statements in an opening statement and in closing argument to say that the harm here caused to Lexi Nunez was the result of the negligence of her mother, Ivy McGowan Castleberry. They got to litigate cause.
But as it pertains to Watchtower, CCJW, and Thompson Falls Congregation, that decision was made for them. I mean, it was already answered yes. I mean, it really, as it pertains to the defendants, they got to argue that some percentage of it was caused by Ivy, but as it pertained to the defendants, so I'm guessing they were more concerned with, is that was predetermined, and it was basically just a trial on damages. It was, did the negligence, which had already been determined because negligence per se had been ruled on by summary judgment, of those named below cause injury to Alexis Nunez, indicate yes or no, and yes is already filled in for all three except for Ivy. So then it's just damages. Apportionment and damages.
Justice Shea, if I might continue. So I've made the first 2 points. The third point is the only issue upon which they filed a motion for directed verdict at the close of our case was our failure to prove that if the authorities had been reported, then something would have been done to protect.
But they already had filed their objections to the verdict form. And in their written objections, they say causation must be determined by the jury. So that argument wasn't waived.
I think that's a decision for this court to make, Your Honor. When you get to trial and your position is, now they had objected pre-trial, but if objecting to pre-trial across the board to a proposed jury instruction or verdict form, if that's sufficient to preserve an issue for appeal, the lesson this court is sending to lawyers is object to everything. Because then you can argue anything you want on appeal. This court
but they also moved for summary judgment on that. I mean, as they opposed the taking causation away. I mean, so they opposed the motion, or excuse me, I guess they opposed your motion to establish causation as a matter of law before sending it to the jury as it pertains to the defendant. So isn't this analogous to when we say if you file a motion in limine, you don't have to object in trial because you preserved it by virtue of your pretrial motion in limine? How is that substantively?
I think it's different under the facts of this case. When you go to trial and you say, we're entitled to defend on the issue of causation, and then you stipulate, and it was on the record, you can look in the record, defense counsel stipulated to a verdict form that had yes built in it. That was by agreement of the parties, stipulated to on the record. But now we're arguing the judge was wrong. If you're going to tell the judge you're wrong to take causation away from us, you have an obligation as a trial attorney to give that judge the opportunity to correct what you said was an error. And I get the whole point that the court looks at the entire record and you can preserve. But you need to look at the facts of this case. In this case, they stipulated that they were liable. So I do want to get to the issue that now is a part of their argument on appeal, and that is...
Just a minute. I want to come back. I'm sorry.
Sure.
Two things. One, what do you say about the assertion that's in their brief and that they made again today, that at the summary judgment stage, you acknowledged that there were genuine issues of material fact, and then the court essentially sua sponte granted summary judgment on this negligence per se issue?
Thank you, Justice. If you look at our brief in response to their motion for partial summary judgment on the negligence per se issue, our primary argument was that we did establish the elements of negligence per se. As is common among us attorneys, you always throw in the fallback argument that says that at the very least there are disputed issues of material fact. But here's where the situation changed. In preparing the final pretrial order, the parties identified several issues of law that were to be decided as a matter of law before trial. You can find that in CR 96. And so the parties said to the judge, these are issues of law. Please decide them as a matter of law before trial. That's the equivalent to their cross motion. And so, yeah, we had an alternative argument at one point, but we took it away by the time we filed the final pretrial.
Well, I have a couple things. I mean, you're asking us to apply the rule one way when we're looking at your situation, another way when we're looking at the appellants. And I don't want to switch gears. I do want to have a chance. I guess if you have something else to say to Justice Banner first, I want to hear it, but I have a question there.
Sure.
Before you move on, I just want to come back to the question I asked. You fielded it as a causation question. And I didn't intend it as such. I was back on the issue as to whether or not they fell within the reporting exception. And my question is based upon the evidentiary inconsistency that you pointed out earlier, was there not, or how was there not, a genuine issue of material fact as to whether or not this communication to clergy was confidential or not confidential with an established church policy and practice.
Justice Sanford, because, for two reasons, one of which is the exception they rely on by its plain language includes the word requires to be kept confidential. The judge had before him, at CR 51, Exhibit C and D, sworn deposition testimony from two elders saying they could report. So the requirement statute was gone. The requirement element was gone.
Okay, so thank you, Justice Sanford. That gets right back to where my other question was. So it says choose. That's a decision being made within church governance. Okay, and earlier you said that if we say that that's a matter that would infringe upon the First Amendment, if we looked into that, then in every case where a religious organization is failing to report, it would be okay under the statute. Remember making that statement?
I think I said if this court granted religious institutions the right to define for themselves the outer bounds of confidentiality, it would eliminate the statute as it relates to religious institutions.
That's right. And so my question is, counsel, is the reverse is true as well. In other words, what are we doing to the exception if we start looking at what the decision-making process is within the church? You can't, it's one way or the other.
Justice McKinnon, respectfully, I don't think it has to be that way. I think this court interprets statute. That's the function of the court, is to interpret a statute. And when a statute says it's required to be kept confidential, and the representatives of the religious institution say we could have reported a known child abuser, then where's the requirement element met? It simply isn't met. That's a different case and a different set of facts. It is not the facts that Judge Manley had before him. He had before him testimony, sworn deposition testimony from elders.
Counsel, take it a step further. Would you want church doctrine to say always it's required to be kept confidential? Any allegation of child abuse? Is that what we want?
No, certainly don't. And
so,
that's our argument, is we do not want that exception broadly construed to allow religious institutions to fail to report, when required, a known child sex abuser, which is what happened in this case. He was a confessed. They had Peter, getting back to the
so you object to their decision not to report. And you say that, okay, if they were required to report, then that exception would apply. And if the church doctrine said that they were required to report, they would fall under the exception.
That's not the way I read the statute, Justice McKinnon. The way I read the statute is if you're going to rely on that exception, you meet the elements of it. One of which is it's required to be kept confidential. They didn't meet that element.
I'm sorry, I misused the word. So if you've got a church doctrine that says required to be kept confidential, and it's their doctrine, you may not agree with it or not, that could be a pretty broad catch.
Yes, it could.
And so that's what you're advocating here, rather than a smaller catch in terms of what could be kept confidential, required to be kept confidential under church doctrine. In other words, we're allowing right now, if we go with the appellant's argument, the opportunity to make a decision, a discretion from the church, to say, yes, this case has to be reported, but this case doesn't.
We don't know why. We can assume from their opening brief, and all we can do is assume because they didn't put on any proof that asserted privilege, we can assume that that advice was wrong. And incorrect legal advice is not a defense to liability under a mandatory reporting statute.
What do you make of the documents they submitted after trial? I mean, I read your objection in the district court about why they shouldn't consider them. But what about, in light of the arguments that are being made by both parties here today, how should we deal with those?
Those are not part of the record, should not properly be considered at all by this court. Point number one. Point number two, the director of the Department of Public Health and Human Services is not a lawyer. This court interprets the law. Number three, Gross versus Myers said, when you have knowledge that children are at risk of being abused, it is appropriate to report to the authorities. So that letter is irrelevant and immaterial and inadmissible.
So moving on, I guess I want to hear what you have to say about this vicarious liability. The defendants asserted that the plaintiffs never attempted to establish that the Montana elders were agents of Watchtower or CJW. And so how did you establish that?
Look at CR 77 and the extensive affidavits that all support a number of points on agency you just discussed this week. And I might just tick them off for you. Elders are appointed by CCJW and Watchtower. They have to be approved by the service department. Elders must follow established policies that are established by Watchtower and CCJW. And I'm talking about local elders as well as all other elders in the church. They are not free to set their own policies. Elders may be removed if they do not follow the policies as instructed or established by Watchtower and CCJW. In this case, every elder in the trial testimony substantiates this from Douglas Chapel. Every elder who was involved in the decision not to report Max Reyes, including the local elders, did as instructed and exactly as the Jehovah's Witnesses wanted them to do. They all, in doing so, acted in furtherance of their principal's interest. And this court has recognized that you do not abrogate a common law principle like vicarious liability unless the legislature in its statute says it's abrogated. If it wasn't abrogated here, this court's authorities stand for the proposition that vicarious liability is a principle that applies to statutory negligence as well as common law negligence. I would like, if I could, because my time is running short, to focus the court's attention on our constitutional challenge to the $10 million cap. And I'll try to be brief. I would also just mention in our brief, there was substantial credible evidence at trial to establish malice. And the definition of malice that the jury was properly instructed on includes deliberately proceeds to act with indifference to the high probability of injury to the plaintiff. The jury had before it plenty of evidence, including evidence that every elder acted according to instructions, did exactly what the Jehovah's Witnesses wanted them to do, and Elder Herberger testified that if presented with the same situation today, he would handle it exactly the same way and not report Max Reyes.
Briefly address the Attorney General's argument that he failed to adequately develop any legal argument for unconstitutionality in the briefs.
Yeah, and Your Honor, I apologize to the court for that. We as attorneys, when we're dealing with page limitations and word limitations, we have to make judgment calls. It was not well briefed, which is why we did preserve our issues. What I'd like to do is just focus you on what we believe are the two theories. We do not rely on the right to jury trial as a basis for claiming the $10 million is unconstitutional. We rely exclusively on equal protection and on substantive due process. And if, give me 1 second here, I've got a minute left. With respect to equal protection, you first ask, what are the classes? Here we have similar, we do not challenge the 3% cap. I want that clearly understood. You have similarly situated plaintiffs who are treated dissimilarly. A plaintiff that sues a smaller corporation with modest net worth versus a plaintiff that sues a large corporation with substantial net worth, like this, with $1.6 billion in net worth. You then ask, under the rational basis standard, if they're treated unequally, is it arbitrary? And this $10 million cap is totally arbitrary. It does not serve the governmental purpose of punishment or deterrence. It is also unnecessary in light of this court's jurisprudence and the jurisprudence from the United States Supreme Court under the Due Process Clause when you analyze the constitutionality of a punitive damage award. They have plenty of protection pursuant to the due process analysis against a runaway punitive damage award. So both under the rational basis test, under both equal protection and under substantive due process, we contend that the $10 million cap is arbitrary and unconstitutional. Thank the court for your time. I finished.
You got 17 seconds.
Thank you. May I conclude?
Again.
So in conclusion, what we would ask is that this court, in conducting its de novo review, determine that the orders entered by the district court were correct, affirm the jury's verdict on compensatory damages, affirm the jury's determination, which is supported by substantial credible evidence that malice existed, and affirm the jury's award of punitive damages. Thank you.
Now you have another question. Mr. Taylor.
May it please the court. Just a couple of things to review. One of them has to do with the status of the trial and what opportunity we had to present evidence as it related to causation. If you have the court's order, CR 107, it's also tab B in the handout. On page 6 of that tab, it says, regarding the report in 2004, this court finds no genuine issue of material fact as to whether a report was made to members of the clergy, agents of defendants. Defendants failed to report as mandated. Defendants are liable for the harm of Alexis Nunez caused by Max Reyes after the 2004 report as a matter of law. The question left to the jury is what the appropriate amount of damages to award Alexis Nunez. The court's plain language takes away the issue of causation from the jury. What is more, the issue of the exception needs some clarification. As it related to the testimony regarding the exception, the testimony was pre-trial that individual elders are instructed whether or not they have a duty to report, not whether or not they can or cannot report under the law. They are only taught whether or not they have a duty, and that's it. They are not told they cannot or they must not. They're only told whether the law obligates them to.
So how does that pertain to his argument then that because they have a choice, there's not a requirement under the statute?
And so it goes to the established beliefs and practices of Jehovah's Witnesses. I hate to go into Bible, but at Romans chapter 13 and verse 1, it instructs Christians to be in subjection to the superior authorities. At Proverbs chapter 29 and verse 5, it also instructs Christians that they ought to be or maintain confidentiality. And so those two principles operate in a balance. When the law requires a report, elders report. When the law does not require a report, elders endeavor to maintain confidentiality. The conversation with Mr. Chappell was whether or not an elder could breach confidence. Could he go ahead and do it? And the answer is, although we preach confidentiality, individual elders have to make their own conscience-based decision. And in response to that question, Mr. Chappell further testified how an elder comports himself in connection with that verse on confidentiality is a matter that he will work out with God. It's not a matter with the corporation or the it's a matter that he has, because we can't legislate consciences.
So how does that square then with the exception under subsection C that in order for the requirement to not be required to report under the law, under the civil law, the communication must be required to be confidential either by canon law, church doctrine, or established church practice? Which of those three? I mean, it seems like almost like if you're going to give the discretion to the individual elder, it's kind of an ad hoc church practice.
It is an established church practice in that the disclosures are limited to those with the need to know. So when we talked about Mr. Reyes knowing and the children knowing, those disclosures were required in our practice of handling sin and repentance. So we meet with the accused when the accused is involved in wrongdoing. It also involves those who may have been victimized by the sin.
And but as I understand it, and so correct me if I'm wrong, because as I understand it from Mr. Malloy's argument, is that, and I thought this is the way I understood what you were saying, is that it is still to report to the civil authorities is a matter of conscience of the individual elder. Is that not correct?
It is slightly off in that the Bible directs confidentiality, and that is our established church practice. But we do not penalize or otherwise punish people when they exercise their own conscience. We feel that that's best reserved for God and not for humans to judge their conscience, even though it is our established church practice. And I think it's consistent with the statute. If you go back to the statute, Section 205 of the statute defines confidentiality. And in that section of the statute, it identifies 26 different types of disclosures that can be made while the matter still maintains its confidential status. In fact, one of the exceptions under 205 is H, and it allows for disclosure of the information to a person about whom the report has been made. So you can disclose it to the accused under the reporting statute, and it maintains its confidential status under Section 205. Now that relates to the Department of Public Health, and not to FACE, but it gives insight into this understanding that confidentiality is, unfortunately, somewhat of a nebulous term.
So, Counsel, I just want to get a handle on the church, what the doctrine says. Are you saying that the underlying principle is confidentiality?
Correct.
That the doctrine wants the communication to be kept confidential, but you don't penalize somebody who reports.
Correct.
Where can I find that in those records?
So it would be in the Mr. Chapel Declaration. I think it's also Exhibit 6 to...
That's all right.
Yeah.
CR 37. CR 37 is the Declaration of Doug Chapel.
My question is, after the church imposed its discipline on Mr. Reyes, then that was in fact known to the entire congregation.
So in our practices, the reason why a person was disciplined is not disclosed. The fact that they were disciplined is disclosed. But the substance of the communications between Max and the elders, and also between those who were victimized by his sin, was not disclosed beyond those who had a religious need to know. And that was the elders and those involved.
If one of the people involved told other people in the church what happened at that point.
So established church practice governs the elders and their role as confidentiality. It does not govern others who are participants. It governs because this whole...
No, but if the incident itself wasn't confidential, then we don't need to define what the statute.
If the disclosure was presented in the context of addressing sin and repentance, and it was viewed as confidential when the elders heard of it, it was viewed as confidential when Peter disclosed it. And as I mentioned earlier, he stood in his own privilege that he was not going to disclose what he told the elders. So even in his own impression, which fits more nicely with 4B, he understood that his communication was confidential.
But under 4C then, Mr. Herberger, in his own matter of personal conscience, he decided this was a render unto Caesar moment, and he was going to report to the civil authorities. He was allowed to do that, correct?
He would have had to have accounted to God for his adherence to the principle found in Proverbs 25.
But church doctrine, established church practice, or canon law did not require him to keep that confidence.
It required it, but it wouldn't penalize a violation. It required it. It absolutely required it.
So you're just talking about a penalty for violation of church doctrine, correct? The doctrine itself required the communication to be confidential.
Correct. And so we kindly request of this court, in reviewing this matter, that it also consider the vital role that these types of communications play, not only in our faith, but in all faiths, and the redemptive value in being allowed to consult with the minister, to speak with the minister. And we hope that this court, as it reviews this matter, decides to vacate the punitive damages and also extend to Jehovah's Witnesses and other minority faiths the protection provided under exception 4C. And we know that this court is a defender of religious liberties, and so we ask and submit that the only appropriate relief is reversal, remand, with instructions to the district court to enter judgment in appellant's favor.
Counsel, I want to just ask the same question that Justice Sandefur was pressing Mr. Malloy on. If it's in terms of trying to reconcile the freedom to whether we're looking at it, and I get there's the nuance there, but deciding the nuance on whether there was a requirement not to report or to maintain the confidentiality, and whether this was an established church doctrine or that, is that not a question of fact for the jury to consider? Because, and I'm thinking of an instance here, and I'm not questioning the sincerity of your position here necessarily as much as, if you have something, the other danger of when you have a situation where a religion may just decide to use that as a shield, and whether that is something that should be tested as a question of fact.
I think that it's important to allow evidence and to hear evidence about that subject. And I would simply add that at the time of the court's ruling, the evidence, even viewed in a light most favorable to the non-movement, only showed that it was established church practice. So I believe the district court had enough evidence at the time of its ruling to decide the issue. Every deponent testified that this was established church practice. There was no contrary evidence in the record. And I should explain that sometimes this is the result of what happens when a district court, sua sponte, makes its own motion and judges it. And then we find ourselves in this position where you don't have a record that is adequately developed for some of the issues. However, on that particular issue of established church practice, the weight of the evidence only went one way, which in appellant's opinion warrants application of subsection 4C to the beliefs and practices of Jehovah's Witnesses. Thank you very much. I submit.
Thank you very much to both counsel. The court will take this matter under advisement at this time, and we will issue an opinion in due course. Also, my thanks to the law school for the introduction, particularly Professor Ford, and also thank the State Bar for holding this argument. Thank you very much.